know that these families had a lot of time in front of Judge Godola, I made sure to review the previous hearings and make sure that I went over the prior ordinance matter. And so I reviewed hearings from June 15th, 2022, October 30th of 2023, December 11th of 2023, April 22nd of 2024, and May 20th of 2024. I also reviewed the Guardian of Lighthouse report that was entered back in 2024. I noted that there was an ex parte that was entered at the beginning of this case back in 2021. Then an ex parte was entered in September of 2023. That was due to an allegation of physical violence and discipline.
If I can state for the record, those were pure allegations, there was no factual evidence put on the record.
I said allegation.
But they were filed anyway, so the ex parte was, it wasn't done on factual evidence.
Yep. So again, so as I was going, there was an allegation at that point. Guardian of Light was appointed, and then we got parenting time continued in May of 2024. And then now we are here before the court on the Mr. Hughes' motion to change custody. So Attorney Zerka, I'll let you argue your motion first, and then I'll allow Mr. Renfro to respond. And then from that point, then Attorney Zerka, you'll get an opportunity to respond to anything that new that Mr. Renfro brings up, and then we'll go from there.
Thank you. Judge, I just want the court to be fully aware that my client, prior to...
I object. Transverse Pagliaro, attorneys cannot be witness or give false testimony before the court. The attorney's testimony before the court are not facts.
Okay. Mr. Renfro,
I demand that the court strike all testimony of Elder Zerka, oral and written, from the record.
Mr. Renfro, this is a motion hearing. It's not an evidentiary hearing. It's just a motion hearing.
It's testimony.
He gets to argue on behalf of his client, and then you get to argue. I'm not even swearing you in. You get to argue your part too, okay? Because you're representing yourself, and I'll let you do that as well. Please allow the motion hearing to take place, though, okay?
Yes.
Thank you. Go ahead.
Judge, my client has always taken a position in this case prior to the filing of this motion, even when the incidents happened with Mr. Renfro and the child when his parental time was suspended. It's difficult sometimes because he stood before the court on many occasions after when he assaulted his son, admitting in fact that he did strike his son. So whether he believes it's permissible or not permissible to do it, and he basically in the court admitted that the incident happened. Even with that said, Judge, my client has never opposed his week on, week off parenting time. And she was all for him complying with Judge Godola's rulings. And as soon as he complied, then he would get his parenting time back. She never took the position that she wanted to reverse the agreement that they made when the judgment of divorce was entered, up until the bottom of this motion. And Judge, as stated in the motion, and I'm 100% certain you read the motion, I'm 100% certain you know the situation that's happening, but when Mr. Renfro took it upon himself to withhold the child without getting permission from the court to do so, he violated the court's order. He kept the child missed about 2 weeks of school because of his actions. Even when he took the child for his parenting time, he still didn't take the child back to school. So a child at the age of 10 missing third grade and 2 weeks at third grade is not a good idea, and that's concerning to my client. So when you add up this action with things that happened prior to the last order being entered, when you take all that together, there's obviously some kind of problem and disconnect with his mental health. And so my client believes that that's a huge problem moving forward. allowing Mr. Renfro to keep on having parenting time with his 10-year-old child. And not taking him to school is nothing that should be tolerated by the court. The child should be in school each and every day. So he's proven out that he's not going to do that. So that in and of itself is a change in circumstance and proper cause for the court to have a hearing on the issue of custody. So, I mean, with that said, Judge, I think we definitely met the threshold of proper cause or change in circumstance to warrant the court to have a hearing. I would ask that up until the time of hearing, that the parenting time not go back to the week after the prom, because he will again violate a court order, and this 10-year-old child who's in third grade will miss mornings of school, which just are not right. And I think the only way the court can ensure that this child goes to school is to allow the child to remain with mom until the court can have a full evidentiary hearing on the issue of chain of custody.
Mr. Renner?
So, I object to Albert Zerger's testimony. Bizarre. He's saying my actions are bizarre, and he's making testimony on my mental state. He's not a practice. Does not practice law, practice medicine. He do not make allegations about my mental state that he doesn't even know me. He's not a party to me or this case. He doesn't know. He doesn't know. He wasn't there to witness. So I object to the allegations of mentally incompetent, bizarre. I've studied the law for quite a while. The reason why I withheld my son was for protecting him. He's been telling me what's been going on at home. You know, Kelly Shaheen has a new boyfriend, all right, that my son knows about. But she also has several others that my son's seen, but her boyfriend doesn't know about. So she's unstable with relationships. Okay. Oh yeah, also I wanted to object, let me get my objections. So, I object to Albert Zerka saying that I will never get my son to school. I was protecting my son, and I would inform the school that it'd be a couple weeks. I knew motions would be filed.
How much school
Calling
does
me
one
mental. I object to my son going to school smelling like marijuana. Those are his words. All other investigations, I said he's going to school coming from counties, smell like marijuana. I will say, whether I do or don't partake in the marijuana, it's not a crime, my son. I promise you. And again, to fix his mental issues, the only one with mental issues here, I have evidence, is Kelly Shaheen. She has the messages. I will bring them in, I'll submit them as evidence. And possibly, maybe we need to petition the court for other evaluations, because what's been going on in this case, forcing my son, trained killers came to my house trying to kick my door out and come to my window with court orders. And they told me 2 judges said they could do it. Lawfully, constitutionally, Supreme Law way, they're not allowed to do it. Traumatized my son because I was trying to protect him. I tried to talk to them about that. I tried telling them what was going on. They ignored it. They came back with 10 or 12 cops. Tried to kick my door and crawl through the window. The orders that were given did not contain a court seal. No evidence of that. No discovery. So, I object to these proceedings. I do not consent in the Declaration of Independence. It talks about being governed is consent only. I signed the divorce decree because I was tricked. I did not know I was giving up my rights to my son. Those are natural and God-given. I'm very spiritual and religious. When I discipline my son, it's because the good book tells me to. All right? I do not discipline him every day. I'm not a bother to my son. It was one time, probably a couple years, that I disciplined my kid. And she made a big deal because my life was going good. Hers not so much. She has a boyfriend that has to borrow his son's car to get around. My son will not be taught how to be a drunkard. The good book tells me how to raise my son. That's my God-given inheritance. Mine, born unto me with my flesh and blood. But now this other man gets to drink and drive with my son, whether it's 1 or 3 drinks. I don't think so. I do not consent. My son is a testimony. He sees it. He's 10. Age of reason is 7. He can speak for himself. Fourth Amendment violation has been violated, search, seizure, and my right to privacy. You've drugged me from private capacity to public commerce. Make it. I violated 18 U.S.C. 1950. I was trying to protect my son away from being, there's been drug abuse for 20 years with Kelly Sheen. 20 years. It's documented. I have the documents, I have the timeline. Nothing has said she has gotten clean. It's all there. She treated me like crap. She wasn't a good mother at all. She wasn't a good wife. She stayed on the couch for 2 years doing pharmaceutical drugs. Couldn't even come out of it. I've seen her crawl on the ground like a dog trying to get out of our dog room. I have people that can testify. She got high as hell for years. My son shouldn't have to live no longer through this. And her boyfriend that's watching my son, she ain't serious to him. While she's rubbing other people and my son in my face while I'm taking him to school and this and that. No. My son knows who's in and out of the house. My son knows what's going on. He is the testimony, and I have evidence for whatever else is left. So, she works 5-6 days a week. Who's watching my son? Who watches him? Everybody else but the people who brought him into this world. That's not okay with me. I don't want her friends watching my kid. I don't want her boyfriend watching my kid. That he's mine to raise. And their lives, they need to fix it when they worry about everybody else. I'm doing very well with my life. I want a company, small, but it's a company. And I'm doing it on my own. I studied the law. I've won multiple court cases. Multiple. And, oh yeah, I object to the petition for the mental health evaluation. I do not consent, and if it is pushed, that'd be a Nuremberg violation of Article 6, Section 3. And that's brought in through CFR 50.24, 50.25. So, I object to ex parte. I want my son back immediately. These courts are out of its jurisdiction and out of its law capacity. You're outside the scope of the law with this one. I demand this court vacate these matters and restore my family holding. Perhaps I'm forced to go up to that. And you guys think I'm a joke about that. I have it all motorized. Where are you going, man? I'm here to be heard. Nobody did the proper investigation. It was biased with Julie Griffith. She did not investigate Kelly's. the allegation made against Kelly, their drug use, but she damn sure made sure she investigated me.
Facts.
So, I believe I got everything that I needed at the time, on the record,
Julie Griffith's attendance.
so. I could request a copy of this record at the next hearing, but. Oh, for the record, I am a state national, not a U.S. citizen.
Well, Judge, all I basically want to reiterate to the court is that, this 10-year-old child is the focus here. And, dad taking the child and keeping away from mom is wrong. Dad taking the child and not putting him in school is wrong. And that needs to be rectified. And so I would ask that, you allow mom to continue to have the child, that if dad were to have any type of parenting act at this point, I believe it should be supervised until such time that, the court has a hearing and that he submits himself to a psychological evaluation.
I object. I did, actually get to school for my son. We worked at home together. While I did my law, he did it. It was awesome. It was awesome. Yes, I took him out of school, but I did bring everything home. We did it as long as we could until someone tried to kick my door and took my kid. Committed 18 U.S.C. 1091 Article 8, subsection 6, genocide.
Okay, thank you. All right, so, question I have is, are you gonna allow your child to go to school on your parenting time?
Yes, I will take him to school, and actually, CPS has an investigation going right now, that was me.
Okay.
It wasn't on me. The school has called, Chris has not been going to school watched, nobody knows, he's been being made fun of. I've been contacted, Kelly's been contacted. I have attendance for the last 2 years. He's been tardy because I live on the other side in Burton. I get him to school when I can, every time, unless he misses being sick. But, he's only been sick a few times this year, and then we took out hockey season for, cultural reasons. But I do have attendances. She has missed over 2 weeks last year, when the 8.5 months I had my son removed from me. She missed over 2 weeks. Over 2 weeks. And then this year, she's probably hitting 10 days. So my tardy's a 2 to 10 minutes late, because when I looked at the website, it was stating 8:45. So when I showed up at 8:45 or 8:40, I was 5 to 10 minutes late. That's the target. I live on the other side of town. I get my son there. My son loves me. I love my son. I'm not letting him go. And I object to the petition for the mental evaluation, because obviously the Supreme Court's already stated that a man can do his paperwork. Then he's not mental. This is very good court paperwork, made for higher courts. I'm not trying to blame left, but this has got to get taken care of. I was ignored the last time I was in here. I will not be ignored.
All right, so, really the purpose of today's hearing is to determine whether, the matter should be set for a, trial or a hearing as it relates to the request for change of custody. So this, the purpose of the motion hearing is to figure out whether we're gonna have another date. Attorney Zerka, on behalf of his client, is saying, that they would like to have a hearing as it relates to, custody. And what I've heard from Mr. Renfro is that he's saying that he would also like to have a hearing related to custody. So if, Mr. Renfro, you got something you wanna say?
Well, as long as these hearings can see the evidence and listen, I don't mind. But if they're gonna be biased, like the last time I was in here, I don't consent, I want my son back.
Okay, thank you. I'm gonna issue my ruling on the request for the motion based off of what I've heard from everyone today, and then, we'll go from there. The question really before the board, as it relates to today, is two questions. Number one, should this matter be set for a hearing where evidence would be submitted, where both parties have time and, an opportunity to present evidence? So the first question is, do we meet the threshold for us to have a custody hearing in the first place? And then the second question is, what should that custody be during the pendency? What should the parenting time look like until we have that hearing? Because it will take some time before we can set a date, get our date when we're gonna come back. And so those are the two issues before the board. First issue, everybody agrees with. Attorney Zerka on behalf of his client saying, I want a hearing. Mr. Renfro is saying, I want a hearing, I want an opportunity to present my evidence. So that part is resolved. We will set a date, for a hearing on this matter. No problem on that side. The, second issue is what parenting time should look like in the meantime. And when I went through the guardian ad litem report, what I saw was a lot of the same issues that we are here today on were addressed then. Child smelling like marijuana, getting to school, a lot of the same issues are present. Now the new issue is getting Christopher Jr. to school. That's the big issue is that he didn't go to school for 2 weeks. And so what I want to make sure is that that's going to continue. And since this is a motion hearing, I haven't taken any evidence from anyone, I am not going to change the established custodial environment, which is with both parents having week on, week off parent time. If the minor child is not going to school, and then we have a hearing, and the child's not going to school like they're supposed to, that could be a piece of evidence that would influence the custody hearing. So, my expectation, and that's why I asked Mr. Renfro if the minor child would attend school during his parenting time, and he said he will, so not an issue. So we'll I'm gonna keep the parenting time order as is. Violations of that parenting time order will be taken very seriously when this court does have a hearing and takes evidence from both parties as it relates to the change of custody. But I'm gonna leave the family as they came in today, which is a lot of the issues that were raised back in 2023 and 2024 are still here today. Not much has changed except for, a new judge. But most of the things as far as his family are concerned are pretty similar to where they were before. So I'm gonna leave the parenting time as is, with the current parenting time schedule, which is week on, week off, and there will be a date, parties will get a date for us to return for a custody hearing. Any questions?
Judge, I appreciate what you're saying on the record, and basically saying that the child needs to go to school. The child needs to be at school on time as well, because he's in special ed classes. So missing 5 minutes, although it seems to be no big deal to Mr. Renfro, missing 5 minutes is not good for this child. So the child needs to be to school on time every day.
And if that's not happening, that'll be something that you all can present as evidence when we have a custody hearing about whether parenting time, whether schooling is going appropriately, but that is something that will be addressed when we have a hearing.
I'd like to correct the record also. I am not saying it's okay. I try to better myself with my son every day. But the fact of the matter is, to get my son taken for 3 to 10 minutes, being late for 12 times because I thought the internet said 9:45 or 8:45, it was 8:35. It was a mistake, and it's not gonna happen again. He's been on time every time since then. And, if we can put nitpicking,
to your
Yes.
school, it's not an
Boy,
issue?
I love my son going to school, he loves it. I want him to learn as much as possible. I want him to know what I know. And another thing I wanted to say, have you ever read the William Lynch letters?
I'm sorry.
The William Lynch letters, have you ever read those?
I don't think I am.
So, it was a slave trader from the West Indies. He came to America in the 1700s. Congress had to abolish slavery. So there's a new thing that was created, it's called commerce. And commerce became consent only, because without consent, it's slavery. Declaration of Independence obviously states have the right to not consent to being terminated. So if you parties does not, I have natural rights for my son. My mistakes will be corrected as for my father. I'll do what I gotta do to become a better man, no matter what. So, and I have not shown the court that, oh,